I'd like to give you some tips on taking depositions. First, remember there's three types of deponents. There's parties, there's third-party lay witnesses, and there's expert or professional witnesses. You prepare for each witness in a different way, but there are certain general common rules that apply. First, when you begin the deposition, you should indicate who you are. Make sure you give appropriate instructions concerning that if they don't understand the question, they should let you know. That they should not give head shakes or grunts, that they need to say yes or no to their answers. That they should wait until you finish asking your question before they answer. That they should not use pronouns such as he, she, or it in the answers because sometimes that makes their answers unclear. And they should let you know when and if they need to take a break. Two goals of all depositions, irrespective of the type of witnesses you have, are to, number one, discover the facts, and number two, lock in their testimony. Finally, remember, all objections are preserved other than form of question. If an objection is raised as far as form of question, you are entitled to ask the opposing attorney what is wrong with the form of question. They are required to tell you what is wrong with the form so that you can correct the form of the question and ask it in such a way that the form is proper. If they refuse to do that, just make sure you put on the record that if they would have told you, you would have reworded the question. Make sure you prepare an outline with all of the topics. Depositions often lead you where you don't expect. An outline is critical so that you stay on point. I have a saying, you follow the rabbit down the hole. What do I mean by that? You're asking the question and the witness sort of goes off tangent. Now you need to follow that witness's answers, as I say, down the hole. Find out where that answer is going. Find out what the witness is trying to get at. But once you reach the end of that topic, you come back out of the hole and look at your outline and go back to what you need and what your goal is here. Locking the witness into their testimony. If you have an outline, a diversion of the facts will not divert you from getting to the real point of your deposition. I understand sometimes you have difficult opposing attorneys. Frankly, an attorney defending the deposition should be a potted plant, other than objections as to the form of the question, and those objections, frankly, should be rarely raised unless they're compound questions. It is improper for an objection to be made that is intended to give the witness an answer. It is also improper to berate, yell, or be sarcastic to a witness. If you encounter such activity, put it on the record. Ask opposing attorney to stop it. If the attorney won't stop it, then try calling the judge. At least in bankruptcy court, if the judge is not in court, if they're available, they will take a call and on the record will stop that sort of activities. If the activity is so bad, you can always stop the deposition and take it to the judge. Make sure you have on the record what is transpiring. If you don't have a video recording of the deposition, you must verbally describe what is going on so that the judge, when it comes before he or she, knows what is going on. If you have a difficult witness, such as a witness who won't answer or gives a vague answer, keep asking the same question. They'll get the hint. If the attorney, your opposing attorney, objects on asked and answered, ignore it. Just keep asking the question. You can always ask a witness, do they understand the question? Could they repeat the question back to you? Just never lose sight of the two goals. And that is to do discovery and to lock in the testimony of a witness. Thank you.